What's up, everybody? We're here to finally watch this hearing together about Brian Kohberger and his lawyers trying to block cameras from the courtroom. And this, I guess, this is just part one of it. We may have to do this video in multiple parts because I can't speed up the video itself to 1.5 speed. It's an hour and 36 minutes long. So we are not going to do a 3-hour stream today. So it's going to be, I'm going to do it in multiple parts. We'll see if we're able to kind of cut it together when I have time throughout the next day or two to record this and watch it with you. We may release it as it gets done, or we may release it together in just one mega video. But hopefully you guys enjoy this content and enjoy this channel. If you do, hit that like button and subscribe to our page. I've heard a lot about this hearing already. I couldn't find it anywhere but on Court TV, and I heard the sound is not the best. And again, I can't bump it to 1.5 speed, but it sounds like it's not on YouTube. So we're just going to watch. We're going to be thankful for what we've got and not complain about, oh, it's just on this side, or the quality is not as good as it is on YouTube and I can't speed it up. We're just going to take what we got and we're going to listen to it together, see what we can learn, see what we can talk about, see if I can answer your questions in the comments. But let's get to it, and we will watch as much as we can here in part one of this video. And the premise of this is, we already read the motion. They are going to call experts to show how cameras in the courtroom create an unfair situation for a criminal defendant in this situation. And by the way, I'm sure some of you are going to notice some new merch. I don't know if this is new and out on the website yet or not out on the website yet, but it's pretty cool. It's elementary, and it's just kind of the elements that make up lawyer. Just fun stuff, you know? All right, let's get to it.
Thanks very much. Please be seated. Good afternoon, everybody.
Also, I know people aren't going to be happy. There are no closed captions, so turn closed captions on your computer, and you guys can listen on 1.5 speed. I'm jealous of you, but we are going to listen to it just on its normal speed.
Okay, let's get on the record, please. We are now on the record, State versus Brian C. Kohberger, C.R. 29222805 in the courtroom. Mr. Kohberger is in the courtroom with his attorneys, Ms. Taylor, Mr. Logston, and I'm sorry, I missed you because you were behind the screen earlier, but also Ms. Massa is also present. Representing the state is Mr. Thompson and Mr. Rudley, and we're really here for the motion Associated Press et al. I'll call you Non-Party Media Coalition. So Ms. Olson and Mr. Courtroom could come up, or I don't know if it's just going to be you, Ms. Olson?
I would be the only one arguing for.
Okay, well, thank you. So we have a lot of things to sort of sort through. And I know some of your clients are listening on Zoom, and I can't look at all of you while I'm looking at here, but I just wanted to acknowledge that. So I think we probably need to start with the motion to intervene. But let me just tell you my thoughts about that. I think that after reading the Supreme Court's decision, the coalition has standing, and so I think you're entitled to be here and make the argument. But I don't know that I need.
So first off, they file a motion that they can even intervene and have this hearing and argue this motion and have the judge make this decision. The judge is basically saying, you're probably right. I'll probably grant that. If you want to argue, you can. You never argue if the judge says you've already won.
To grant intervention, but I don't know. What's your view of that?
Your Honor, we think just to have the clearest record possible that the court should grant intervention for this limited purpose. We think that would frankly also be helpful should the situation arise again, since there's simply no rule that sets out whether we can do this or not, which is among the reasons we went the wrong place the first time. So we would ask the court grant the motion. I don't intend to offer any of the arguments other than was offered in the briefing round.
Okay, let me go to Mr. Rudley or Mr. Thompson.
Your Honor, we don't have an objection to granting the motion to intervene for the limited purpose of challenging the amended non-dissemination order.
Ms. Taylor?
We don't have an objection.
Okay, great. Okay, so I'll grant that request for the limited purpose. The reason I was worried about that is I don't want the media to be really, so to speak, a party that has to be involved in so many.
He doesn't want the media to have to be notified every time there's a deposition or on the service list for everything they do in the case. And they probably don't, they would not even be able to do that. But that's why they talk about for limited purposes, again, for a clear record. So everybody's on the same page. So nobody feels left out and everybody understands what their role is and what their rights are.
Things that we're going to be dealing with. So, but I will grant that request for the limited purpose of what we're talking about here.
Thank you, Your Honor. And then there's just one other housekeeping matter. As the court indicated, some of our clients in the coalition are participating by Zoom. They have been informed and directed that they may not record the proceeding that's occurring by Zoom, but they may report on it after the fact, just like any reporter here in the courtroom, or as if they were with us here in person as our party representatives.
Okay, agreed.
So she's saying, by the way, just because they're not on Zoom doesn't mean they can't report on it, right? We want to be able to report on it. We are the media coalition. Judge says, okay.
Thank you, Your Honor.
All right. The next issue, though, is this motion for shortened time. I didn't sign that proposed order. Apparently, there's an objection, and let me hear from you first about what that might mean for what we're going to do today.
Well, Your Honor, I think given that the hearing has been scheduled today, the court has in essence granted the motion to shorten time unless it would be allowed. Don't just slow down. Yeah, sorry about that. I think the court has indicated it's going to grant that motion. We're having the argument on it today. I think the one potential sort of hiccup there or sticking point there might be with respect to the evidence that Mr. Kohberger wants to introduce, to which we do object, given we became aware of it 3 days ago, and there simply hasn't been enough time to vet the information that they seek to provide. And as we set out in our reply brief, we think it's not appropriate anyway, given it's time for them to have introduced evidence in support of the gag order that's in place was in January of this year. So I think that might be the only sort of hiccup with respect to whether the court might end up shortening time or giving them additional time to present that evidence.
Well, I haven't approved the shortened time because I wanted to hear from counsel how they viewed that. I know when I talked to Mr. Crone last time, I was concerned about the short time, and I was really, maybe it wasn't very direct, but encouraged that we allowed a little more time because I know there was going to be a lot of briefing. At that time, I think Mr. Logston, said that it's going to be really difficult for us to get things together for an expert, but we'll do the best we can, is what I remember. And so here we are. I was also concerned about the massive amount of briefing that I had to go through very quickly, which I did. And I want to make sure, because this is a very important decision, that everybody has the opportunity to weigh in with what they want to present. So maybe I should go to Mr. Logston and see.
May I offer one other comment?
Well, yes, go ahead.
So Your Honor, understand, I think we all agree that this is an important matter to address, and that there are significant interests at stake among both the parties and then the interveners. And I think our concern in wanting to move it forward sooner rather than later is that this gag order has been in place since January, since virtually the inception of the case, and it has rendered harm to our clients' interests. And so that's why we wanted to move forward more quickly. And that's why we had offered, we thought, as sort of a interim step, and we were at the hearing this morning, we heard your comments to Mr. Longson at the end, but that's why we had sort of offered as a interim step, vacating the gag order pending a more fulsome evidentiary hearing.
By the way, I mean, just so you know, I find that to be a very kind of inaccurate and distasteful name for the order. And I've had trouble about that for a long time, and it's not called that. So I would appreciate not using that term. It's distasteful, and I think it's inaccurate, and I think it's been overstated, just the impact of that order, just to let you know.
Thank you.
When a judge says something like, just to let you know, it's like, well, you're the judge and this is your courtroom and you're going to be making the decision on this non-dissemination, don't call it a gag order. And so he's saying it's distasteful. It's been over exaggerated how restrictive it's been. Who over exaggerated it? Well, probably the media is what he's going to say. And so, I mean, from the jump, and just like the last hearing, this judge does not seem like he's on the side of the media. That does not mean he's going to ban cameras from the courtroom. But what I think he is doing, and rightfully so, is cautioning the media and everybody talking about this case. Do not convict Brian Kohberger in the court of public opinion and push that. Do not twist things. Do not over sensationalize things. Do not look at him clenching his jaw and saying he must be guilty. Do not read an objection by the state to mean, oh, they must have evidence and he's guaranteed to be guilty, whatever it may be. Don't do that. If you want to report what's going on, report the facts, let people listen, give them public access to this trial and to this proceeding, not a made-for-TV docuseries on Netflix. That should not be your job as the media. I think that's what he's really trying to get across.
Yeah.
Okay. Well, and so you are, why don't I go to Mr. Lawson and we'll see how we feel about the presentation of the evidence and or expert testimony. Go ahead.
Your Honor, we have two witnesses. We also filed, as I'm sure the court is aware, a motion that we believe the court has the ability to take judicial notice of the media coverage in this case. The media, as we understand it, is essentially objecting to there being a record made at this point. Our stance is this is a live issue, and this will not stop being a live issue so long as our client is in this case. And
What he's saying is it's a live issue, meaning things are always going to be changing. We're going to be getting new information. We may get another expert later. The media objecting to us making a record, saying that the media, taking judicial notice of the media attention of this case or allowing us to call witnesses to testify is totally inappropriate. If they want you to make a call, we want to present record evidence. You should consider that evidence when making your decision in the case. If they want to call people, they can. If they don't feel like they have enough time, let's delay it and continue it out and kick it out. But they're also filing motions to shorten the time. So which is it, Judge? I think it's a valid argument that he's making. And obviously we know the court lets him call the two witnesses today. I don't know whether the court takes judicial notice of the media attention, but I think the defense is right in this aspect that it's always going to be changing. If they're going to file a motion, we're going to look for record evidence to try and, make our argument. They can do the same thing. And if they need more time, we're willing to give it to them. They're the ones that don't want to take more time.
And as the facts, or even if you get in the United States Supreme Court case to come down a year from now, it changes too. But as things change, everyone has the right to come into this courtroom and say, we'd like to have the non-dissemination order reconsidered, amended in ways that are going to match with what's actually happening. The media has made the point that when this originally was put in place, it was just the parties agreeing that we wanted to make sure that we were doing everything in court and not doing it to the press. And so we didn't, at the time, feel the need to make a big record about what was going on. I think the court mentioned that.
And just to clarify, in case you can't hear, he's just saying at the time the non-dissemination order was agreed on, it was agreed to by the parties, which is exactly who has to agree to something like this. We didn't need to make record evidence above what we did and we discussed at the time. The media said that was a big deal basically in their motion that we didn't set a record or make a record evidence. Well, now we're doing it. They're also complaining about it now, Judge. We just feel like when it's necessary, we'll do it. When it's not, we won't. All the parties agreed. It was a stipulated thing at that point.
To some extent, what's going on is somewhat obvious. And while we would concur with that, given the media's point and given some of the case law out there, we thought it would be wisest to make a record at the very least of the amount of coverage, of the consistency of the coverage, and to some extent of the substance of that coverage. And that's what.
So the amount and the consistency of coverage is going to be very easy to prove. The more difficult thing is, what is the substance of that coverage? Is it bad? Is it prejudicial? Is it damning to Kohberger? Is it something that's going to poison the jury pool and make this process harder and not give him a fair trial? That's where the judge's decision lies. Just because there's a lot of media attention or consistent media attention does not mean we have to have this non-dissemination order. It doesn't mean we have to ban cameras, none of that.
What we associate with the talking about from company TrueScope. And then we also brought in a psychologist, professor of psychology from Eastern Washington University, to basically just kind of talk about why we care. And there are reasons we care that we talked about in the brief that aren't related even to the biases and things like that. We just have overall concerns about, as a country, how do we resolve these cases? Is it in the press or is it in court? And those are issues that we don't necessarily need these witnesses to get to. But to the extent that the United States Supreme Court has clearly shown that we do concern ourselves with the effect on jurors, even the effect on ourselves and our witnesses, that we brought in a social psychologist who can explain what those issues are a little bit better than we just sort of understand. In terms of, our position is important in these things. We think that they're best to make the record in the case. And I think the court is correct. We thought it would be better having time so that everybody could take their best shot. I feel like we did a pretty good job of warning everyone that we were going to be bringing witnesses today. But that, at the same time.
Again, just a little shot. Like, we wanted everybody to have enough time. They didn't. We let everybody know we were calling witnesses, and now we're here with less time.
Like I said, it's a live issue. The court could issue something today where the media could go back, find themselves an expert that they think blows our whole case out of the water, and then come right back to court and say, well, let's do this again. And that doesn't make any sense to me. So I certainly don't have an issue with the media deciding what they'd like to do is have additional time to find their own witnesses, for that matter.
Judge, I have no objection to a continuance of this hearing. Basically is what he's saying, because he knows the non-dissemination order and everything is going to stay in place.
Care more. We're not going to object to any request to move this hearing.
Thanks, sir. Mr. Bradley, you
Your Honor,
addressed that. Maybe you want to come up for the mic.
Oh.
Thank you.
I'll be brief. The state has no position on the motion to shorten time or hear additional evidence.
Thank you. All right, so Ms. Olson, let me back up. I'll tell you where I am on this. Well, number one, I agree with Mr. Logsdon that this is a moving process, and analyzing this going back to whenever it was imposed is not particularly relevant at this point. A lot of other things have happened. If there was no order in place right now, I could impose it today based upon the evidence that was presented. But there's not really any evidence presented yet, and that's why I asked for potential evidence to support the record. I think we can probably agree that this is a high profile case. There's a lot of interest. There's a lot of misinformation and disinformation out there in the public, and that's quite concerning. My job is to protect the First Amendment as well as the Sixth Amendment, and there is a balancing in that. I don't think there's any question about any of that. So I'm inclined to allow, okay, the testimony and the evidence. I'm inclined to.
We know that he does.
Take judicial notice of the submission of Mr. Kohberger, but I am happy to put this out to give you and your clients an opportunity to respond to that, because I know it's incredibly short notice.
Thank you, Your Honor. It's, yeah, three days notice, but we address some of that. We prefer to go forward today. And as Mr. Longston just acknowledged, if we feel like there's evidence that we find later, we'll probably just file a motion to reconsider it. And I would just like to address.
So the catch-all in this, in case you didn't hear her mention it, is if we get more evidence or if we feel like we need to present evidence or witnesses, we'll file a motion to reconsider. We'll present our evidence, we'll present our witnesses, and then maybe the judge can make a different determination. But she's right. If the point of what they're trying to do is make a decision as to whether or not the non-dissemination order is going to continue, then what we really need to decide is it going to continue based on what the defense has? Then we can come later, and if we want to add more evidence from the media, then the judge can, of course, like we said, reconsider.
One point, we understand that things evolve, and we're at a different point today on June 9th of 2023 from where the two parties were on first, I think, January the 3rd, and then with the court in chambers, with no court reporter taking down anything that happened, where you had to file a redacted memo, and then the amended non-dissemination order came out. We understand we're in a different place, but our point is that the court enters that without any findings of fact that warranted such a non-dissemination order that was what we assert is what order was now was overbroad and was procedurally deficient. And that's where the argument is. There is a First Amendment harm that occurs from a non-dissemination order that is overbroad and where there was simply no opportunity for anyone other than the parties to weigh in behind closed doors with the court. And I was here this morning, as I heard Mr. Gray say that he disagreed with the record that's been made on that. But I think that's a significant concern, and that the court should be concerned about the procedure that was used initially to enter that non-dissemination order. And that's why we continue to take the position that if the court feels a more fulsome record is needed, that the order in place is simply not justified by what the court did back in January, and it should be vacated pending the development of that more.
So she's saying now the procedure of doing it in chambers and not having a record is inappropriate, and therefore the court should throw that one out and come up with another one. Highly unlikely that's going to happen.
Whether that's accurate or not, I mean, that's why I'm inclined to allow any of the parties and the media to add to the record. I just want to remind everybody.
One of the other issues, the judge is not going to want to do this hearing 5 times and continue to supplement and continue to reconsider. So he will probably be a little frustrated with the media if that's their plan, to just do it that way.
This initial order was an agreement. It was a stipulation.
He's also going back to her saying, I'm not going to throw it out. This initial order was an agreement and a stipulation, and therefore it was done appropriately the way that it was done. So stop making that argument, basically.
It wasn't that Judge Marshall just pulled it out as, air. It was an agreement between the parties. There are only 2 parties to protect the 6th Amendment. That was the reason for that. And I would note, because I think this is missed in the discussion, that this was going heavy well before Mr. Kohberger's arrest. So there was a lot of speculation, a lot of criticism, a lot of bad information, and that would trigger for any lawyer for either side to try to protect the integrity of the investigation and the future court process. So just try to, I do think that this thing has kind of grown a bit out of proportion from where it started and where it is now. Because obviously, if you look at a newspaper or the TV or YouTube or TikTok, or I don't look at any of it, but the media has freely talked about this case. So I think that's really kind of the issue. Like, do we have a responsibility to talk to the lawyers about releasing information that shouldn't be released to the public, and allow the media to follow the rule of, or the First Amendment freely, which they have. What I hope is that they do it responsibly and professionally and accurately. But that's really up to the media. I can only control so much, and you can control only so much of your clients and the media that are not traditional. That is really the struggle, and that's why the order was entered originally. Just to give you some background.
Understand.
Sounds like he agrees the original order was necessary. So what has changed to make it unnecessary? It's only gotten worse from that perspective, not better. So that's a little tell from the judge.
Your Honor, and I would ask my good friend Bill Thompson if I can have a look more. Sorry about that.
Can't even skip ahead.
Well, I mean, I think interveners well understand why the parties did what they did and the interests of the parties in this. Interveners well understand. You know, frankly, for Mr. Thompson, and I've been in Mr. Thompson's position in the capital case.
I know you have, and I know you understand the issues here, and that can collide.
Right, what we know is that the state wants to ensure that its investigation, or that the case that its investigators and its prosecutors put together and presented to a grand jury and obtained an indictment, that they can present that case the strongest way possible without having to worry about external events, and certainly external events they can't control. And we know that Mr. Kohberger and his counsel have a tremendous interest here in fighting for his freedom and likely fighting for his life. I heard the court earlier today, and I think all of us who have practiced in this area at all know this is likely a death penalty case, but that, you know, those are not decisions that have been officially made yet, and that hasn't been put before the court, but that's why Ms. Massoff has been appointed to help represent Mr. Kohberger. She's an excellent attorney. I know her well. She will do a very good job for him.
Interesting, right? Maybe some things to report on. It is likely a death penalty case, which we all understand, but that decision hasn't been made. The clock is ticking on those 60 days. This attorney has sat in the seat that Mr. Thompson sits in, prosecuting a death penalty case. It is literally life or death decisions for Brian Kohberger. This death penalty certified attorney has additionally been appointed, which all signs point to death penalty coming. So you can read between the lines. I'm sure the media reported on this after the fact, and she's just pointing out some things, again, tipping the hand as to what we think is going to happen in the future in this case.
And I know that they have an interest in making sure that when it...
She's also arguing right now that the two sides, the two parties, have an interest in this non-dissemination order. However, the public interest is something that needs to be weighed. And that's why she was arguing back in the judge's chambers when the stipulation decision was made, nobody was considering the public and the First Amendment right. Now, the judge is saying that's unfair. The judge was, but the two parties stipulated and agreed. And now she's trying to highlight the fact that there is another group of people that are involved that are important, and that's the public.
It comes time to pick a jury, if this is a case that ends up going to trial, that they can pick jurors who will fairly and impartially hear the evidence and make a decision based on the things that they hear from the witness stand and not based on what they see on Twitter or the internet or watching the news. And that is a fundamental interest of this entire system, which frankly I spent most of my career working with.
Well put, thank you.
But there are also, this court has tools in addition to non-dissemination orders to make sure that there is the best chance to get a fair and impartial jury when this case is heard, aside from a non-dissemination order, which I'll come back to the parts where I find to be overbroad and not having been procedurally accurate. There's probing voir dire. There are jury questionnaires. There's change of venue. There will be the passage of time, and I think that's where this is a potential, because this is a potential death penalty case. That comes into play. If the state files a notice of death penalty and it becomes a death penalty case, I would be stunned if this case went to trial on October the 2nd of 2023, because the defense will need to do a mitigation.
Once again, another little tidbit we can pick up from somebody who's practiced there, who knows all these lawyers, is probably talking this. I mean, it sounds like she's almost like reporting what she's guessing, but she doesn't think there's any way this case is going to go to trial in October, which is something I said earlier. But unless they really want to push for speedy trial, I just don't think that's going to happen in this case. Now, maybe they will allow continuances if it is a death penalty case without Kohberger having to waive his right to a speedy trial, but we'll see. She does not think this case is going to trial in October.
Investigation. The defense will need to look at experts from a host of areas who will be able to present evidence about Mr. Kohberger, his life, and why the aggravating factors that would perhaps the state would.
And again, the death penalty just adds a bunch of work and things you have to do, like put together mitigating factors, aggravating factors, if it's a death penalty case.
Why those should apply and why the jury should choose a different sentence, if it gets to that point after a guilt phase. That takes a substantial period of time, years in many cases. And the passage of time, I understand, we've looked at all of the materials, not in great detail, the materials that Mr. Logsdon submitted from Ms. Saucier and the professor from Eastern Washington. And we understand that there was a lot of publicity. Now, I will tell you, one of the things that was most surprising in the Duncan case, and I gotta say also, when you're doing a big case like that, you're just looking at that case, you think that's all anybody thinks about. But the most surprising thing to me when we picked the jury in the Duncan case, 3 years after the murders, was that there were people who hadn't even heard about it. I mean, that's a case where, granted, the trial there happened in Boise. That's a case where, you didn't have social media to the same extent yet. But there were cars in Coeur d'Alene driving around with Kill Duncan bumper stickers. And there was a donut shop that had on its, they had a reader board, Kill Duncan. That's pretty prejudicial pretrial publicity, and those things would get picked up in the media. So that passage of time, with the probing voir dire, the questionnaire, and the change of venue, all did a lot to ensure that there was a fair and impartial jury that was impaneled. And so those tools we would submit are available to this court. Because in addition to the very important interests that Mr. Kohberger has, and the very important interests that the state has, and I think as Mr. Ledley acknowledged this morning, the state also has an interest in ensuring there's a fair trial. The media does have an interest in enforcing order.
It's not just the media, but also the public, right? The public wants a fair and proper trial so that we don't have appeals, we don't have issues, we don't re-victimize the victims with another trial or thinking he might get off because of something that happened at trial. Everybody's got an interest in a fair trial.
The dictates of the First Amendment and the free press. And those are equally important principles, at least at the stage of beginning to weigh them, Your Honor. It's through the members of the media and the press that the public learns about these proceedings, that the public is able to understand how the criminal justice system functions, that the public is able to understand how the prosecutors perform, how the defense attorneys perform. That's how they learn about details of the investigation when they're released, either in the courtroom or through release through the probable cause affidavit, so they can make their independent judgments on how is our system working, so they can be educated, just as the court did this morning when it started the hearing.
Boom. Exactly what we said. That's what we said in our last video. As the court educated the public on standing silent or different things. That's the point of having cameras and media attention in this courtroom and on this case. For the public to be educated, for the public to understand how the system works. These are things that I preach all the time on this channel. Now, the difference is if the court feels that this education and understanding of the system is going to create an unfair trial or a biased jury pool or not allow Bryan Kohberger to have a fair fight for his life here, then the court should and will keep the non-dissemination order, ban cameras, do all of that. So that is what the court has to balance. And we can sit here and talk about it. This lawyer can argue about it. I can talk to you. I can read your comments. We can discuss it together and learn from each other and what we all think. And some of you are going to think, let me know. As we sit right now, do you think the non-dissemination order should stay or go? Let me know in the comments. So we can have these kinds of discussions. But at the end of the day, that's why we have judges. He is going to have to make a call. He is going to have to make a decision here. That's why he wears the black robe.
This morning by pointing out and explaining why someone would come into court and not enter a plea when called upon to do so, then the court has to enter a plea for them. And those who have been in the criminal justice system have seen that before. So it's that kind of educating that can be done by the court, by the people who actually know about the proceedings. I see no reason why after that proceeding, Mr. Thompson might not have been able to, or Mr. Lawson and Ms. Taylor, been able to answer a question about, wow, well, that's unusual. Can you really do that? And someone say, well, actually, under the rules of criminal procedure in Idaho or under case law in Idaho, you actually can just not stand silent and not enter a plea, and then the court has to enter not guilty pleas for you. That would have been a very helpful thing to have done. And I think it is educational things like that that can be relayed through the media, that the current non-dissemination order restricts these attorneys we're speaking about, or really any attorney, because it's the way it's phrased, any attorney with interest, for a party with interest in the proceeding. That's pretty broad. That's extremely broad. It's not just Mr. Thompson. It's not just Mr. Lobson, Ms. Taylor, and Ms. Nathoff. What does that mean to be a party in interest in the proceeding? We talked about the motion to intervene. We wanted to make sure it was a limited purpose so that we suddenly don't become party with an interest in the proceeding, and then I can't walk outside and talk about what went on in court. So what we're asking for is the court also to look at what is the First Amendment, what role does it play in the court's analysis, and how can it balance those First Amendment rights and use those other tools that are available to it, particularly at this stage of the proceeding, to ensure that the Sixth Amendment right is observed and that the First Amendment right is observed. And we think, Your Honor, in doing that, you have to take a look at the non-dissemination order and apply strict scrutiny analysis. There was lots in the briefing about strict scrutiny analysis. We think the court gets there two different ways. One, because we view this as a prior restraint. In order to have news or publication, you have to have not only print the information, but you have to be able to receive it. And if you can't receive it, you can't present it to the public.
Is there law on that?
There is, Your Honor. There is, Your Honor. It's in our briefing. And I would ask the court to take a look at pages 15 and 19. It's not in one of the big three Supreme Court cases we've all talked about. It comes primarily from the Young case, but that's where that comes from. There's nothing in those three Supreme Court cases that says that you don't apply strict scrutiny when it's a restraint on something other than the media, other than perhaps the Gentile case where it says they're talking about the lawyers, and it says that you still have to be able to show that it's prejudicial publicity. And then you have to have a narrowly tailored tool that's designed to restrict it. And Your Honor, regardless of what the test is, there has to be prejudicial pretrial publicity.
That's the big question. Finally, we're getting there. Not just that there is pretrial publicity, but that it is prejudicial. It's what I mentioned earlier. So how are they going to prove that it's prejudicial? The defense.
That could prejudice Mr. Kohberger's right to a fair trial. So publicity generally, and I think this is where Mr. Lawson submits Ms. Sausier's information. There's no reason to think that publicity generally is prejudicial. It's a publicity about the case, and it allows people to hear about the case. But some of the things people are hearing about the case may not be all that flattering for the state. It may be not prejudicial to Mr. Kohberger, and may suggest things about the investigation and how it was done. So publicity in and of itself is not prejudicial, and that's why.
If you ask some people, they'll say that's because there is nothing that's good for Kohberger that could be leaked or in the press. But she's right. I mean, there could be something really good that happens that's going to make people think, oh, maybe he is innocent. Maybe we should wait until the trial. I mean, he's presumed innocent at this point, but maybe there will be some alibi that people believe in the general public and it could sway them the other way. That's what she's arguing. And I will tell you, there are some people in the media that will make the argument that is why he wants the gag order, because he has nothing good, because it's all bad, and because he's guilty. I don't agree with that. But she is basically forcing their hand, saying, well, maybe there'll be some good stuff. And if there is, then it's prejudicial to not have the media report on it.
I think when we get to what is out there, that courts typically rely on first blush is Idaho Rule of Professional Conduct 3.6. And those 9 items of what attorneys or parties in the litigation may not comment on. Those are rules that are vetted, and they're the same as the ABA rules and the basic rules that every lawyer has to follow without, you can't, if you're a prosecutor, you don't get to walk out of the courtroom and say, well, in this case, we've got the guy because X, Y, Z, whatever. And if you're, you just can't do that under the rules of professional conduct. And there's no reason to think any of these lawyers, who all are fine officers of the court, are going to ignore their obligations under Rule 3.6. I understand their desire and their interest in having something more prophylactic so that they can operate in a way that doesn't, this way, frankly, just don't have to worry about that. But it's our position that the First Amendment requires more and much more, and requires a narrow tailoring. And that when you have a non-dissemination order that starts out and says all extrajudicial judicial statements, it cannot be made. And
I can fix that, can't I?
sure.
I mean, so if I just, and I kind of raised this morning too, that if I am more specific about who is touched by this order and what can people say and what can't they say, then that would help your concerns, wouldn't it?
It would, Your Honor.
And I'm acknowledging this because your motion is to completely vacate it.
Absolutely.
He's saying, is there a way that I could edit it or change it or make it more specific? Maybe admitting it's a little too vague or overbroad. You could read into that a little bit. But he's saying, is there a way for me to do something like that?
We are, and the reason it's that, to completely vacate it, is because we don't feel it's narrowly tailored. And so a overbroad, non-narrowly tailored order that, and I respect what the court said about procedurally how it came into place. That might be one where we just have to agree to disagree. But it's our position that such an order should not be in place. If the court then wants to enter another order, then it has to do something that is designed to address or limit substantially prejudicial material, prejudicial pretrial publicity, and make sure that it's narrowly tailored. And that's why I think, rule.
She's saying if you throw it out, then you do another one. You need to actually follow the rules this time, which weren't followed last time. And we're going to be there to make sure that they're followed appropriately. It's basically what she's saying.
3.6 continues to sort of be the guiding star on that, because it lists the things that tend to be most prejudicial. And so certainly, if the court takes a different approach, we will look at that, and we would certainly hope that the current order we think is overbroad and procedurally deficient, and we recognize the court's ability, to hear all that's going to hear, and if it chooses to craft something and still thinks one is appropriate, obviously we'll take a look at that and see whether we think it still suffers from the same deficiencies as the current amended non-dissemination order. I would also say, Your Honor, because I heard your questions to Mr. Gray.
Yeah, I'm glad you're here. So yeah, you might want to address.
And so this would be our position with the concept generally, setting aside, our position that it shouldn't be there at all. But I think that limited to Rule 3.6 is palatable, at least because that's the obligation that the lawyers on both sides already have. I think it would be very difficult to then have a list of things that you could say. You could say this, but you can't say this, because then it would be impossible to think of every possible statement that could be made. But if there's clear direction on the statements that cannot be made, and they are the things that are set out expressly in Rule 3.6, that is very clear direction is consistent with the Idaho rules of professional conduct and with the sort of no guessing for the people who do want to provide adequate guidance and information. And then we would also ask the court not to do something about the language that says attorneys for all interested parties. I think, frankly, that's sort of just inherently vague as to what that means. And when there are very specific parties here before the court, I think that the court could really could narrow that a tremendous amount. And I heard the dialogue this morning with Mr. Gray regarding witnesses, and I will say, Your Honor, that's obviously not. I think our preference would be witnesses not be included. But when one looks at, for example, the family member witnesses.
So comparing and contrasting what her and Shannon Gray are arguing about, she wants it to be even less restrictive than Shannon Gray. Shannon Gray basically, I do not have a problem with him. It seems like a lot of people online have problems with him, but he is kind of wanting a Shannon Gray carve out of the non-dissemination order. She wants a much larger carve out for the media in general, including witnesses and other people, so we can actually know as the public what's going on in the case, be educated about it, let everybody know our feelings on the process and what's going on. So it's a very different argument.
And the fact that they may be called, certainly, if there is a sentencing phase of this, and they may be called by the prosecution to show victim impact, to provide that information. There's very detailed law on what you can have a family member say in a capital sentencing hearing. And it's usually the kind of thing that is, my child was a great kid, they brought, there was a lot of everybody's life. Here's the video of them dancing at their fifth grade Christmas program. And that sort of thing. It's not details about the case. So for those reasons, we think something that restricts witnesses who are not going to be fact witnesses in the guilt phase, we think that would certainly be overbroad as well.
Okay, so let's go back to, because we kind of, that was great. Thank you. I appreciate everything that you said. That, I am going to grant the request to present the evidence, or I don't know, just the submissions, we'll just say, and take judicial notice of that and allow for the testimony. But you will have an opportunity to come back if you choose to do that.
Well, I'll probably do some cross-examination today. It probably won't be as tight as it would be if I had an opportunity.
And that's a way to protect yourself, protect the record, allow not limiting yourself. So she'll say, I'll do some cross today, because again, we'll take our first bite at the apple today. That's what the media is going to do. First bite at the apple. We get to hear the evidence, but we may want to bring further evidence. We may want to re-cross-examine these people when we've had more time to prepare. So by saying we want to shorten the time, but also saying it's not fair because they didn't give us enough notice, you're kind of protecting yourself as a little CYA being done by the media.
Absolutely.
And the judge is allowing it.
And I think, Your Honor, just to be clear, we made some arguments in our reply brief about why these individuals are not the experts. They would never qualify as experts under the federal rules of criminal or civil procedure based on the things that they list in their CVs and their prior work. If they're only offering this associated to say
a little expert voir dire, she's saying these people are not experts. No way they would ever be qualified as experts on this topic. Interesting. I don't know what the judge says about this.
there's lots of publicity about this case. I don't think anyone's going to disagree with this. But I would point the court to now, and then I don't know if Mr. Lawson asked her about this on direct, but in her report, and she's got some little tables, and it's not, the version we have is not tabulated, but there are two tables, and one says authority figures share a voice, and then non-authority figures share a voice. And on authority figures share a voice, one of the people that's listed on there is David Nye. I don't know why David Nye is someone that they're saying is an authority figure on all of this. David Nye is a federal district court judge in Idaho. As the court was, maybe they meant Jeff Nye, who I think is assisting Mr. Thompson, but that's, I anticipate is an error in the report. And then if you look at the next page, non-authority figures share a voice, and then share a voice media coverage, the person with the greatest stories in the data set is Rebecca Boone, who's an AP reporter, and then the same thing with shared voice media coverage. And of course, the AP stories run all over the country, and they get shared in different publications. So I suspect that might be one of the things Ms. Sauce will say about that. But the definition she uses in her key terms defined is authority figures are experts who are currently working on a case. That's too much caffeine this morning. Authority figures are experts who are currently working on the case. Well, David Nye is not currently working on the case. And then non-authority figures are, per definition, experts who currently work in or formerly worked in the field of law enforcement, police or FBI law, such as lawyers or other court-related personnel, but who are not working on this case. Rebecca Boone isn't any of those things, and she's the primary person they put forward in that area. So if the court wants to consider that, I mean, I think just right off the bat, there are a number of things that make it inherently unreliable.
Let me just be candid. I mean, I'm not going to put a lot of weight on that because, as you said, starting out is, I mean, there's no question about how much information has been poured out about this case. I'm allowing Mr. Kohberger to make a record, okay, because that's something that that has been raised by you and your clients, that there's not a record to support this, to justify it. So I feel an obligation to let everybody weigh in with what they think justifies an order. And I don't disagree with what you're saying about narrowing or being more specific. One of the questions I heard you talk about prophylactic, and I think that's an interesting question when you talk about other options to deal with a fair trial. Going to another venue, for example, or sequential. Yes, thank you. That is complicated. It's expensive. It's time consuming. And so if we can be prophylactic about it by limiting, okay, what lawyers who have a different standard, okay, lawyers who are actually directly involved in the case have more credence, okay, in the public. And that's a reason to restrict that. And that's why I don't like the term gag order, because nobody's really gagging about it, okay? These are lawyers who already are restrained by ethics and professional.
If it's not a gag order and you're relying on ethics to make lawyers say and do what they should do ethically and morally, then you shouldn't need a non-dissemination order. So I really like this judge, but I disagree with him there. I think it is a bit gagging, which is appropriate in certain situations. So I just want to make sure that that is something that we all recognize. It's not just because I'm saying it is gagging somebody or it is restrictive. That doesn't mean I have a problem with it or I think that it's wrong. But I do think it is an order that is restrictive more than just the rules of ethics, or else we wouldn't need it.
So that's really what we're talking about, to kind of do what we can, even though I don't even think the media can really control all the information that's going out there every minute, right at this moment. And so this is not the same world as it was 10 years ago or 5 years ago. And it is troubling for the media, the ethical, hardworking media, and the information that's swirling around in the world. I don't know what the answer is, but it's a serious threat to a fair trial and the credibility of media. It's just a side speech. I apologize.
And I'm not sure that anyone would disagree with that. I mean, we live in an age where finding out what the facts are is more and more difficult with every day. And both the participants in this criminal justice system, the court, lawyers for any party, and the members of the media, we all participate in systems that are designed to be fact-based and that are designed, when they function well, to get the information out that's truthful and accurate and through a process that is most appropriate. And I don't think anyone would disagree with you, Your Honor, that right now, that there are certain, because everyone can have a blog or be on Twitter or be on any, there are so many, social media channels out there now that a person my age does not hardly know any of them. But those are all certainly out there. And no order from this court, respectfully, Your Honor, is going to reduce any of that. But when there's an order from this court that limits the ability for people who
they're all agreeing basically that people talking about it on social media, it is what it is. That's legal. They're allowed to do that. So if that's happening, and I think this is kind of a good argument by the media, if that is happening, what is this non-dissemination order really protecting? If people are allowed to have YouTube shows and talk about it on TikTok and Instagram and connect the dots and say he's guilty all over the place, regardless of what leaks or whatever it is that they have, they're still going to do that. But we are not able to report the actual facts. The people involved in the case are not able to talk about the actual facts, which could maybe give that context or make that better or have people connecting real dots. Now, Kohberger or the state or the judge could argue, well, giving them more facts just gives them more to twist and gives them more to condemn and gives them more to use as poison.
have actual facts and good information to provide statements about things like the court this morning that can educate people about the process. Certainly, no one's expecting that Mr. Thompson or Ms. Taylor or Mr. Logsdon or Ms. Massoff are going to, if the court lists non-dissemination order, are going to run out and tell you everything they know about this case. They're not. And so I think, Your Honor, when if the court, it sounds to me like the court is inclined to have some sort of Second Amendment.
If we look back in other cases, especially like Stephen Avery and stuff like that, when you think about the fact that what prosecutors said publicly in those press conferences and how horrible it is, when we think of some other cases, is it borderline ethical or breaking the rules of ethics? Like she's saying, even if you lift this, these lawyers here aren't going to go spout off everything they know. That would be totally inappropriate. That would potentially violate confidentiality. That would potentially violate bar rules. So what are we actually trying to accomplish with this non-dissemination order?
I would urge you to make it as narrow as possible so that the actual facts can be relayed to the members of the media. And I think when you look at who the media coalition is that came before this court, I mean, this is a group of Idaho-based, some Washington state-based. It's hard to be in this part of the state of Idaho and not be completely familiar with Washington, and then some national outlets that continue to have an outstanding reputation. And what they want is for their reporters to be able to obtain accurate information and information that is of the kind that is not,
basically she's like, Judge, these are reputable people. These are reputable media companies. Come on. Give them the benefit of the doubt here. I won't mention any names that she's trying to differentiate from herself or from them.
Understand the things that probably the lawyers are not going to tell them, but information that might help the public better understand all of this. Because the other thing that is just so is the background of all of this is these are tragic events that affected this community, the entire state of Idaho, and you probably know that who doesn't know. You and I know who doesn't know someone in Moscow who was affected by this tragedy. And I think as part of that, and there are people who really have an appetite for accurate information about this case. And what we would ask this court is not to have any sort of non-dissemination order that restricts the public's ability to understand these proceedings and to get accurate information.
Okay, so thank you. What I would like to see, maybe we all like to see, is the media actually doing more complete analysis of process, okay, and explain to the public why we do what we have to do in protecting a fair trial. I haven't seen any of that.
So now he's specifically commenting on what the media is and is not reporting. He's like, why aren't more media people pushing the fact that this may be necessary? We need to first and foremost protect a fair trial for the defendant. His life is on the line, for the state, for them to be able to do their job, for the public, so that we don't have an appeal and more tax dollars wasted, all because of something that we could have prevented in the first place with a non-dissemination order. So he's specifically saying, like, I've looked at the reporting, I've looked at the media. Why aren't they doing more of what you're saying, being ethical and helping the process and trying to keep a fair trial in order here? Why aren't they doing more of that? Why is it so obvious what they're doing and exactly what the defense is arguing here?
I'm not out there following the news.
Sorry. So again, I have not watched this. This is our first time watching. He's like, why aren't they doing this? And he's like, well, I'm not out there following it. I'm not out there following it. Well, then how do you know they're not doing that, Judge? That would be my question.
Carefully. I think our local press has been really fair and pretty balanced, and I appreciate that they
Now he's saying the local press is fair and balanced. Which is it?
are talking about some of the details and explaining kind of why things are happening. It would be nice to see more of that instead of the sensationalizing that we are seeing in the national media. So,
You ever have people from like other states that you talk to and they think, oh, healthcare is so much better in my state, or education is so much better in my state. And he's like, the reporting is so much better locally, but nationally it's horrible. It's like, I don't know if I've noticed a huge difference locally and nationally from the reporting on this case, but you guys can let me know if you have. Let me know in the comments if you think it's just the national news and not local Idaho news that's basically reporting similar things.
and by the way, I haven't made a decision at this point. I mean, when I ask questions like this, I'm testing my thoughts about where we might end up. So I don't know if you want to address anything else about the evidence or further your argument. I kind of interrupted you there.
No, I think we made it all the way through the things that I had planned to tell the court about the standard it should use to analyze this, the reasons it should vacate the current non-dissemination order, and then our thoughts on if the court is inclined to look at a different measure to ensure a fair trial, that it use some of those tools that are available to it other than a non-dissemination order, particularly when realistically the trial in this case is probably at least 2 years out because of all the things that the defense will have to do if this is a capital case, and they'll do it well. And you don't do that in about 4 months.
That remains to be seen.
I understand.
I understand what you're saying
Yeah.
too. So, and you're sticking to strict scrutiny.
Yes, Your Honor. I think for 2 reasons, Your Honor. The first is that because we view it as a prior restraint, and because in order to both, it has to be, in order to report information, you have to be able to gather information. And I would direct the court to page 15 of our brief for that. And then separately, Your Honor, when the court is balancing 2 competing constitutional rights, we would submit that the court has to apply strict scrutiny. I think that's on page 19 of our brief, Your Honor. And then finally, I would say,
she seems like a really smart lawyer, regardless of, whether you agree with her arguments or not. I think she is making a cogent argument here.
I mean, Mr. Wallerton submitted a bunch of materials to the court. If the court's inclination is to sort of give them the weight they deserve, I'm not sure I'll spend a lot more time on it, other than I wanted to point out there's 2 quick errors that I was able to find in Ms. Salcier's tables. But we submitted declarations from reporters who I think their experiences illustrate sort of what happens when you have an overall non-dissemination order like this, where people who really are not involved in the proceedings, people who are being asked about topics that aren't really directly related to the facts of the case, they're cited in the non-dissemination order for reasons they can't talk to the media. And that just, I think, sort of reinforces why you're going to get the things that we see on social media and the internet, and the things that the court will express concern about.
Well, let's just, one of the problems there is, I think that a lot of the media were suggesting that the order was much broader than it actually was. And so maybe people
See, to me, what I don't like about this is saying, I think the media reported it's much broader. It's not really that broad. Well, do you really want people to guess and potentially accidentally violate a court order. Nobody wants to do that, especially not lawyers or professionals or even media. They don't want the judge to be pissed at them because they violated a court order because they misread it. They're going to always side with the abundance of caution, as they should. I shouldn't say they always do, but they should. They should act in an abundance of caution and not violate a court order.
Responded to that. The other option would be that they were just using it as an excuse because they didn't want to talk to a reporter. And that's their right, right?
Absolutely, Your Honor. That's what they said to the reporters, and that's what those reporters said in their declarations to the court.
So let's just say, just for the sake of discussion, that if I just lifted this order, what are you after that the media doesn't already have? You want to be able to talk to the prosecutor? You want to talk to the defense attorney? I mean, how far does that go? You know that you just can't open their files.
Absolutely. It would just allow them, it would allow Mr. Lawson, if he wanted to respond to a question in the manner that he did in court today about why Mr. Kohberger stood silent instead of entering pleas, it would allow him to respond to that. It might help them describe what's going on in the court. Something happened in court today, and can you explain what that term means? Things like that. It happens pretty routinely in lots of other criminal cases. It might also then take away, these law enforcement agencies in other locations who are reluctant to respond to public records requests because they're concerned about running afoul of a non-dissemination order issued in another state. There would simply be better sources of information available to reporters. But again, everyone would still have the opportunity to say, I choose not to speak with you. But they wouldn't be prohibited from doing so by the court.
Thank you.
Thank you, Your Honor.
Okay, yeah, I appreciate it. Let me go to Mr. Lee or Mr. Thompson.
Your Honor, the parties discussed Mr. Logston making his presentation first since it's more substantial.
Okay, Mr. Miller.
All right. So now we've heard from the media, and we're going to hear from the parties, and it almost sounds like they have a united front here. So we'll see kind of what the state argues, but I know the defense is the one that's going to call the quote unquote expert witnesses to discuss the media's effect on a fair trial.
Well, we do things a little differently, I guess, of course, because I'm used to putting the evidence on and then we argue. Now I'm a little thrown because we had argument.
You can go ahead and Ms. Olson can come in and question if she wants.
Okay.
We didn't know until we were kind of halfway through the argument about what we were going to do with that.
I understand. So I think I'd like to start by moving the court to take judicial notice of.
By the way, I agree with Mr. Logston. Usually we put on the evidence first, then we make the arguments, as opposed to we're just going to make the arguments. So what's the point of then putting on the evidence after? But let's hear what their arguments are.
The press materials that we provided and essentially have the court acknowledge that it has the power to take judicial notice of the press coverage in this case.
Okay, I'll do so over objection.
Thank you, Judge. And then we'd like to call Ms. Jean Saucier. She is available via Zoom.
Your Honor, you may have been
Yes.
suggesting this,
Come on
but
up.
may I come back up to this?
Yes, come on up so we can hear you.
All right.
Thank you, Ms. Olson.
And may Mr. Colon come up as well, so if.
Sure. Come on up, Mr. Coram. Thank you. Okay, so there she is. Saucier, is that right?
Yes.
Ms. Saucier, could you please raise your right hand?
I guess we're going to hear from the experts before the argument now, which is good. This to me is easier to follow. This hearing is something. It's not the most riveting hearing in the world, but you guys asked for it, and that's why we're here, right?
solemnly swear or affirm that the testimony you give in this case shall be the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right. Thank you, ma'am. Could you please state your name and spell your last for the court reporter?
Yes, Your Honor. Jean Saucier, SJean, SAUCIER.
All right. Thank you, ma'am. Mr. Logston?
Associate, how are you employed?
I am employed.
All right. What I'm going to do is we're going to end part 1 right here. Part 2, we're going to pick up, listen to the testimony, listen to the rest of the arguments, and finish the video at that point. So what I'm probably going to do is combine this all into one video, but in case I don't, thank you for watching. Hit that like button on the way out. All right, part 2 starting now. Hopefully we'll be able to knock out the rest of this video. It is late, the same day that I recorded part 1. But I felt like this was kind of going to get old and stale, so I didn't want to wait too much longer. A lot of people had asked for it, so I wanted to make sure that this was, in fact, something that got done in time so that everybody that asked about it would still care to hear about it. So we are going to knock out part 2, hopefully take the rest of the video, comment on it, get the expert testimony, see what we think, see where we feel the judge is going to lean with this non-dissemination. Don't call it a gag order. Apologize for the more relaxed look, but it's late, just hanging out like Travis Rudolph. You know, this is what I go to bed in. I'm not trying to be aggressive. But I appreciate everybody joining me. If you haven't hit that like button already, now is the perfect time to hit it. Let's get into the rest of the video.
Thank you, ma'am. Mr. Logston?
Associate, how are you employed?
I am employed with a company based in Nebraska, headquartered in Nebraska, called TrueScope.
And what is it that that company does?
TrueScope is a global media monitoring and measurement company. We provide media intelligence data.
And how long has TrueScope been doing that?
Media intelligence data. That's what we're talking about here.
TrueScope has been doing this for 3 years. The company that I worked for previously was acquired by TrueScope. That company was Universal Information Services, and that company had been performing media monitoring and intelligence services for over 50 years.
What does that mean, media monitoring and intelligence services?
What that means is that we, companies such as ours, provide data to corporations, organizations, both in the profit and nonprofit world, to show what's being written about or talked about or communicated about their company or other types of maybe projects or things that they're working on in the world. And it shows media companies pull in that data to show return on investment for maybe a for-profit company or other key metrics.
So basically her company does research to see how many people watch so they can sell ads on how many eyes and impressions and things like that and how many clicks they get. That's what people hire this company to do.
That are being written about or talked about.
And approximately how many clients rely on that service right now?
Currently, we have about 270 clients throughout the world.
And when it comes to how are you able to collect this data? Is it like an algorithm? How does that work?
So it is, there's a lot of technology behind it, but sort of broadly speaking, the way that our system works is it will ingest content. We have licensed data sources that provide to us content via API. That content is pulled in from
all media types from broadcast, print, social, web, and that pulled in via API. And then where that content is housed and stored for the front end of a web platform where our client can review that data, filter that data, chart that data, and that's how they can see what those messages are and where they're sort of have a gauge on the important content of what they need to see.
And what's your role in this?
My role at TrueScope is I've been with the company TrueScope 360 Universal Information Services for almost 8 years. I'm Senior Vice President of Client Success.
She's the Senior Vice President of Client Success.
And in that position, what kind of knowledge do you have of the way in which the company performs its task of collecting this information?
So I am very involved in the customer support, training, onboarding, client demoing. Demos, something that we do to show what the platform looks like, what it can do, the capabilities, the features, functionality. I also lead the team that provide and produce curated reports. We do that for media insight, and we do that for executive daily news.
And what's your understanding of how accurate the data that you gather and produce is?
Our data is extremely accurate and
What is your perception of the data that you gather? So if her answer was, it is what it is. Anything's possible, right? I don't know. Maybe it's good. Maybe it's not. I mean, that would literally cost her company tons of money. So obviously she's going to say it's accurate. Like, what kind of question is that?
authentic. We are not
Maybe how do you test the accuracy of your data? Maybe that's the better question.
our clients rely on us and have relied on us for a long period of time to have data that's coming from licensed sources, the top data sources that are able to provide that data. And I'm not a developer, so I can't speak to the technical details of the ingestion, but our data and the algorithms that we use to process that data is extremely accurate.
Is your company a member of any associations? Is there anybody that makes sure that you're following whatever kind of rules you have to abide by to make sure that you're providing?
This is where I'd love a little skip forward
Absolutely.
button.
We are a member of the International Association of Measurement and Evaluation. That's the leading global, it's called AMEC, and that's the global organization that oversees evaluation and measurement. We also are members of CBEC, which is the World Media Intelligence Congress. The president of our North American company, Todd Murphy, is an executive on the executive board, and he is a VP of CBEC at Congress.
Do you know if you have any kind of margin of error for what you guys produce?
The margin of error for media monitoring is really very low, and that is any margin of error would be as a result of what was published. If something was published inaccurately, we would have that same margin of error.
So you don't get wrong whether or not something was published.
I'm sorry, can you repeat that?
So the fact that something was published and is related to your client's request, you're 100% certain that it's always going to be like a story related to that?
100% certain?
Yes, based on keywords and parameters that we utilize from the client to pull that data.
So we contacted you in this case, is that right?
Yes,
And what is it that we asked you to do?
you asked us to begin to monitor content for all media types about the case.
Yeah, how did we set that up?
So we set up the workspace or the platform, as it's called, and the report. We do that internally with our team of experts. But in order to set up the terms, the messages, and the names tracking, you provided that to us.
And as a result of that, did you create some, what we call them, graphs for the court today?
Yes, we did.
And is that what we have labeled as Exhibit A?
Yes,
And is everything in that true and accurate as to what it is that you created using the software that your company runs?
yes, it is.
I'm going to move to admit Exhibit A.
Any objections?
For purposes of this hearing, no, Your Honor, but I would preserve my objections regarding whether this is appropriate expert information. I can address some of that on cross.
Okay, thank you. Mr. Radler?
So just basically, does this rise to the level of being expert testimony? I apologize if I look a little bored. Her background and qualifications, this so far has been incredibly boring, but let's see how she what we're looking for here is how she can prove how this affects the trial, negatively affecting it, which it might not be this expert. I think there's two witnesses, but how much media attention and exposure there is, how consistent it is, whether it's negative to Brian Kohberger, and then if that has a prejudicial effect on the trial. Those are kind of the questions we're trying to answer here.
Objection.
Okay, anything to respond to that objection?
I guess I'll wait and hear what the rest of the objection turns into, Judge.
Okay, well, I'll accept that. I'll admit this for purposes now, the limited purpose that Ms. Olson has described.
So, Ms. Associate, do you have the exhibit on your screen?
I do.
And is it the same exhibit that was attached to the PDF file, the filing that we did in this case?
Yes,
Can you do a share screen at the first page of that?
yes.
So this is the first page that we see after the exhibit A that I put on the front of it, is that correct?
That's correct.
And what is it that we see in this, I guess we call it a slide?
This is a report that we exported from the TrueScope platform on June 6th, containing data from November 13th, 22 through June 6th, 23. It contains volume, potential impressions, unique authors, metrics over time, key phrases in that particular data set, people mentioned in that data set, organizations mentioned in that data set, location, and media.
Can you go to the next page?
Yes.
And what do we see here?
This is an aggregate total of volume, potential impressions, and unique authors between the dates of November.
Potential impressions. I'd like to know how accurate that is.
13th of 2022, 6th of June 2023.
What does total volume mean?
I'm sorry, can you repeat that? I'm a little muffled.
What does total volume mean?
Total volume is an aggregate total of the volume of media coverage for that time period.
So that's every,
That's every media for every type that we're tracking.
And then what are potential impressions?
Potential impression is a metric that shows it takes into consideration circulation to show what the readership might be.
So nothing. That is almost nothing. It takes into consideration what readership might be. So that's not a number that the court should even consider. Total volume seems like a legit number. Unique authors may seem like a legit number. I also think it's important on how this compares with prior media coverage of just generally like other cases and other things on the news and that media are writing. Is it a lot more? Is it a lot less? As you can see, previous period for the total potential impressions was 500K. So that's what, 4 times? That's 4X. So it's 4 times larger than it usually is. Those are the numbers that are more important, is what is the difference? Not just that, they're writing stories about this case. It's what is the media coverage and the eyeballs on this type of stuff? How is it changing? Are they more interested in Kohberger? Is it negative? Is it prejudicing his trial?
But the potential total readership might be.
So if that number right there is 2.1 billion, you're telling us that potentially there have been 2.1 billion readings.
Correct.
All right.
That would be like saying, so you're saying potentially somebody else might have walked through the store before the crime was committed. You would not be able to argue that.
I think we can probably guess the unique authors, I take it, is just how many different people have written about this. Can we go on to the next page, please?
Yeah.
What do we see here?
This is metrics over time between the 13th of November and the 6th of June of 2023, November of 2022, to the 6th of June of 2023. And this is a chart looking at volume, potential impressions, and social engagement. Social engagement refers to how widespread social shares are. So engagement, shares, likes, etc.
So based on this, we can see that, I mean, it looks like there's never a time when there aren't publications of some kind coming out about this case.
That's correct.
Why does the potential impressions bump go way up back in January and has completely fallen off even as the volume and social engagement go up?
The potential impression typically is going to rise if there has been some significant event on a particular day or in a particular time period.
Okay, but why is it precipitously dropped even as all these stories are coming out? Are you frozen?
No, I'm thinking. I'm not sure that I have a clear answer for that.
So would that tell us that the stuff that's coming out is the volume of stories increases, that there are fewer people looking at whatever kinds of stories those are?
Are you giving her the answer? Is that leading? Objection? She doesn't know why. Which I think if she's an expert and she's going to use these graphs, she needs to know why it goes up and down. That's like the whole point of her testifying, right?
Objection leading.
There we go. Overruled? He just gave her the answer.
I'm sorry, Your Honor, can you repeat that?
Go ahead.
He said overruled.
You can answer the question. The question was,
Okay.
She wanted you to repeat it.
the question was,
Yikes.
would this tell us that even though there's a lot of stories coming out, for example, in May, the actual circulation of those stories is pretty low?
Yes, that would be accurate.
We go to the next page.
Based on what? Explain it to us using your graph.
What is this?
This is what we call a word cloud, and it is a chart that.
Oh my gosh. This is so funny. My buddy used this when we were compiling data for something. I think it was for our home group or something. We were talking about topics that we were going to talk about. And it's like the topics that people were most interested in get bigger, and the ones that people are less interested in get smaller. So like if we're looking at it here, Idaho students was searched more than even Brian Kohberger. Washington State University, the victims' names. And then as you get smaller, it's Idaho campus, Brian Kohberger spelled without a space, the white Hyundai Elantra, Moscow police, and the ones you can barely read, early morning hours, whatever that means, death penalty.
As part of the TrueScope system that shows what some of the key phrases are in any data set with any particular date range. In this case, November 13th through the 20th, November 13th, 2022 through June 6th, 2023. And what it's showing is
Prosecutor Bill Thompson, Latah County, rental home, graduate student, preliminary hearing, knife sheath, felony burglary, first degree murder, old Brian Kohberger, college students, guilty plea. Interesting.
what some of the keywords, key phrases that are organically pulled into the data set based on the parameters we set up. The larger wording means that there are more, the volume is higher for the larger the words are.
The volume is higher. So I don't think this is going off searches. I think this is going off what the media or what the reporting, the articles, all that stuff is about, which is interesting. That this is what the articles are about.
You go to the next page. This one, is there anything we need to know about this? It seems self-explanatory.
I think it is fairly explanatory. Again, it's top people mentioned in the data set for that same time period of November 13th through June 6th.
There's
And
Ann
again,
Taylor.
looking at all media types.
Next page.
You know, what would be helpful to me if I was the judge, I'd be like, give me like, I don't know, Johnny Depp's case. Compare this with that. Or, you know, some other case, Rittenhouse, whatever. Some other case that was in the news that had cameras there. Compare this with that. Lori Vallow in our own backyard. Because, I mean, these numbers look big, but without context, it's hard to really tell. Like, is this more than any other high-profile case? Is it less? How much more is it than your average run-of-the-mill case? Probably a lot more. I'd like to know those comparisons just to know the difference.
The top organizations, same rules apply with within that time period, the parameters that we have set up. These are the top organizations or companies that are listed.
And the next page.
And same thing here, top locations in the data set between the 13th of November of 22 to the 6th of June 2023.
And the next page.
And this is a media type breakdown in a pie chart format between the 13th of November 2022 to the 6th of June 2023. And it's just showing the percentages of content within each media type.
And the next page.
It's hard to see some of these graphs for me.
All right, well, this is the one that everybody wants to talk about. Can you give us an understanding of what it is that we're looking at here?
Yes, this is a chart that our Media Insights team created based on the content that we exported from the TrueScope platform into the all files PDF and what we call share of voice, so that's volume and impressions, and that's showing the time period of 11/13 of 22 through 4 of 23.
Can you explain the share of voice a little bit better?
Sure.
How do you know? I mean, it makes it sound like, if, for example, we're talking about the Moscow police, they get to talk, I guess, what the host, and what does that tell us?
Sure. So what this is showing, the Moscow police, let's focus up a little bit more. So the Moscow police have the highest volume in the data set, and then we put that number in that data set, and the volume is in blue and the distribution is dark. It's purple or blue here. So the Moscow police have the highest volume in the data set. That meant that they were featured or quoted or somehow listed in 24,585 stories. With that, they had the large potential reach, which is central impression, and you see over.
They have the highest volume, farthest potential reach, most impressions. Yeah, we all get that, but how does that affect the trial?
To the right, that we have potential reach listed on the right hand side, and so that is at almost 2 million impressions. So that means that and I'm not, I don't know that you want me to interpret the data, but this is an aggregate look at how far the potential of the messaging from each of these names and or organizations went through the data.
And to the extent that you have listed David and I instead of Jeff and I, is that our bet?
We did not change any of the names that you provided.
Okay, next page, please.
That was the incorrect name. The media lawyer pointed out, like, doesn't make sense. But again, I think it's a nothing burger at the end of the day.
So this is essentially the same thing, is that right?
Correct. That's correct.
And in terms of the concept of what's authority versus non-authority, where did that come from?
Authority versus non-authority came from the law.
I guess what she said came from,
Me, Judge.
oh, you, okay, thank you.
Yes.
Next page, Judge. Sorry. Associate. And this is just another slide comparing Mr.
This
Gray.
was,
Yeah.
correct. So this slide, your office asked us to prepare for these particular names to do a share of voice chart showing what each of them, where each of them fell in that's on the chart.
Is that the last page? Are we done yet?
Hopefully.
Then we have a terms and time.
All right, well, I don't believe I have any other questions for you, but you may get some from some of the other attorneys. Thank you.
Okay, thank you.
Mr. Lawson,
I have a hard copy of Exhibit A. Does the court want that placed in the library?
yes, please. Okay, admitted. Defendants A. Mr. Riley, you want to weigh in at all?
We have no questions, Your Honor.
They're like, nope, we didn't really need her to testify at all, since in fact all the charts just said what they said.
Good afternoon, Ms. Saucier. My name is Wendy Olson. I represent the intervener media.
Good afternoon.
Ms. Saucier, where are you coming to us from?
Do you mean my location?
Yes.
I'm in Chicago, Illinois.
And when did the Kootenai County Public Defender's Office hire you for the work that you've done in this case?
The first day of our agreement was February 15th, 2023.
February the 15th of 2020.
February of 2023. And my guess is she's going to be annoyed that she had 3 days notice when they've had this company on retainer for 4 months.
23.
That's correct.
And in all the data that you've shown here in court and are in Exhibit A, I know that starts at November 13th of 2022 and goes to June 4th of 2023. Why did you start with November the 13th of 2022?
Because that is the date that our client asked us to begin searching, and we were able to pull in historical content previous to the agreement or the data we started searching for most media type.
And I apologize, it's associated with the copy of your report that I have, it's Exhibit A, doesn't have any page numbers that are in it. But if you could look at, I mean, let's just pick the one that is, metrics, well, let's start with the first one, I guess it's page 2 of the A. If you mind putting that back up, Mayor, so we can see it, your report.
Sure.
Right there.
Page 2.
No, sorry, the one above that, the first thing is total volume, 4610. All right, and this one, is there any way that we can tell from this slide how much of that volume occurred from November the 13th of 2022 to December 30th of 2022?
Not from this slide, no.
And is there any way we can tell from this slide how much of that total volume occurred after January the 13th of 2023?
Not from this slide, no.
And then would that be the case for all of those slides? If I'm looking at anything in Exhibit A, the only thing it tells us is what happened over that large period of time, and it's not broken down by date set, correct?
From this slide, it is not broken down.
Yeah, and so if we go to the one
It's
that
for narrow
says,
date, but
I apologize. And for the one that says authority figure share of voice, and again, I don't have the pages, so I apologize. And that one there that says, Moscow police and is just under 25,000. You can't tell us how many of those were before December 30th of 2022, how many were after that, how many were before January the 13th, and how many were after that. Is that correct?
not from this slide, that's correct.
And Ms. Associate, when Mr. Longston asked you the question about David Nye, I assume you don't know who David Nye is, correct?
If you mean personally, no, I do not.
Well, at all, do you know who he is do you learn who he is in the course of all of this?
I did not spend a lot of time looking up or researching any of the authority figures or the non-authority figures.
You just took the information that Mr. Longston provided to you, is that right?
That's correct.
And so you have no idea of knowing whether in fact the person is an appropriate person to include in the data set as an authority figure, or if they're not, is that fair to say?
We utilize.
The answer to this is yes. That is fair to say. She just took the information. Good point made by the media lawyer. We knew this was coming, but I don't know how this helps her win. That's the issue.
The name that we were given from our client based on their knowledge and expertise.
And do you have, as some of the information that you prepared as an addendum anywhere where we can look in order to evaluate your information at that list of names that were provided to you by Mr. Logston?
I'm not sure that I would have the authority to provide that to you.
Okay, well, that's data that you used in your analysis, right?
That's correct.
And with respect to this data set, what do you mean by that, the data set? What is that?
The data set is the volume of coverage that is in our system based on the dates that we have filtered for. So in this case, for these slides, when we filtered 11/13/22 through the date that we created the, each particular chart, in this case, June 4th, 23, to get the most accurate data set, most up-to-date data set.
All right, but what's in that data set? Is it a whole bunch of, like, is it 20 different media sources that you run search terms against? And then somewhere downloaded is all of the stories or whatever you want to call them that come back when you run that set?
So in the platform or the workspace that we have set up for our clients, all of the content that we have ingested since we started working with that client, and this is the case for any client, any coverage that has come in through our system, that has been tagged, for lack of a better word, to try to explain it, that has been pulled into our system is in the platform, a workspace, a web-based workspace, and we have access to pull all of that data or to filter based on a name or organization or any number of many other filtering options.
Okay, I'm still, I guess, again, just not understanding how you get the data set. So is it, like, let's say, on November the 13th of 2022, somebody ran a story about a 911 call made to the Moscow Police Department, and it runs in, and it's an Associated Press story, so it runs somewhere initially, and then it gets picked up by a bunch of other people. How does that get captured in this data set that you're talking about?
So from how that gets captured into this data set is through the front end of our system. That data resides and is housed and stored as, so let's say it was an AP story that is in, that fulfills the parameters that we're searching for. That story will be in the workspace, in the platform, and we're able to pull that based on
I don't feel like she has a great handle on this material. If you want my honest opinion, she's like the client success VP, which means she's probably either a salesperson or customer service, keeping clients happy. She's not the data analyst, which is probably who they needed. That's why this is so painful to get through. She's doing her best to answer, but I don't think she actually knows the answers.
filtering parameters. Let me try to explain it a little bit more clearly.
And are you looking at something, ma'am?
Pardon me?
Are you looking at something as you're trying to provide an additional explanation of what this is?
No, I'm not.
Okay.
Maybe you should.
But we use the front end of our platform, which houses the data that's pulled in from the back end of the platform, and that data is pulled in from our data sources, ingested in a number of different ways, primarily API feeds.
And so is the data like a news story about, that they've given you one of the terms?
Yeah.
Okay.
Yeah, so it's the published content. I'm sorry, maybe I wasn't clear about it. It's the published
So
content.
the actual story would be there, is that right?
That's correct. That's correct.
And for whatever the actual story is in there, to put these charts together, you went through and just basically counted in how many of those stories certain terms appear, is that right?
That's correct.
Okay, so there's no effort to like qualitatively examine what the story has, right? It's simply a counting exercise about how many times certain terms appear in the various media sources that get ingested into your platform, is that right?
Yes, in this case,
So again, it's showing like, what does this really tell us? What do we really learn from this expert, from this report? I don't feel like, I mean, I guess we can just tell the number of articles written and the media attention is there. But outside of that, we don't really even know the substance of what these stories are about outside of key words. They could be positive, they could be negative. Seems like the judge may have his finger on the pulse about what the media is saying about this case, and he doesn't love it. But I'm realizing now that we're not going to hear the last witness since it's only 13 minutes left. So that's the part that they never released. But that's the interesting part to me is how does this affect potential jurors? How does this affect jury pools? How is this prejudicial against Brian Kohberger? How does this affect his Sixth Amendment rights?
And in many of the cases for our clients, we are looking at quantitative total to the policy.
And a lot of times, it's because you want to see what sort of phrases your clients want to see, what sort of phrases are catching on with the media, right?
There could be any number of reasons for doing that.
Including that, right? If you have a new slogan, someone might hire you to see, hey, is our slogan being picked up on Twitter or those sorts of things? Is that right?
That's right.
Okay. And that's sort of where that idea comes around for that word. I forget what you called that, the word thing, where some of the words were bigger than others. Yeah. And so, I have a few more questions for you, Ms. Saucier, although probably everyone else in the courtroom should like this one, sure. So with respect to these charges going out as authority figures share of voices, the next one is a non-authority figure share of voice, correct?
Correct.
And you said that that's a term that came from the County Public Defender's Office, right?
That's correct.
And so that's not a term that you ordinarily use in the work that you do through Truthscope?
That's correct.
And it says that, and I read your definition, and it must be the one that was provided to you that's on, it's not on that page, but it's two further. And it says non-authority figures are experts who currently work in or formerly worked in the field of law enforcement, police or FBI law, such as lawyers or other court-related personnel who are not working on this case, correct?
That's my understanding.
Yeah, well, that's information that was provided to you, right?
Correct.
And so you didn't use really any expertise there. You just used the definition they
Correct.
gave you and counted some stories that had these names in them. Is that right?
The answer is yes.
I'm not quite sure how to answer that question.
The answer is yes.
So let's back up to the one
I
that
could have
says
told you what's in this
non-authority
report.
share of voice. Now, the one above that. Right there, yeah. Right there. And the person that has the highest number there, and I guess there's this other line that talks about potential impressions, I'll come to that in a minute. But this line that says Rebecca Boone, AP reporter, I take it that's information that was provided to you by the Kootenai County Public Defender's Office as well, is that right?
That's correct.
Yeah, do you know,
However,
do you know?
however-
Go ahead, ma'am.
as we're looking at media content, our platform pulls in the content and also takes us to that original published story. So we are able to see if something is written by a reporter, such as was the case here for Rebecca Boone.
Okay, but so she's an AP reporter, but she's not, as far as you know, someone who currently works in or formerly worked in the field of law enforcement, correct?
I do not know anything about her background.
Well, would you agree with me that if she's never currently or formerly worked in the field of law enforcement, law, and those things previously, but is not working on this case, she would not fit the definition of non-authority figures that you used in your analysis?
That's correct.
A lot of negatives in there.
And did you do any sort of quality control on this, Ms. Saucier, to determine whether, in fact, the individuals listed here were persons who currently work in or formerly worked in the field of law enforcement?
Doesn't sound like it.
I did not do background research on the names that we were given from our client, nor did I do background research on names that appeared organically in the data set, which many of these on this chart did.
And so you didn't check whether or not any of these people actually were currently or formerly working in law enforcement, right?
I did not do a deep dive into anyone's background.
Including Ms. Boone's.
That's correct.
And Ms. Alcine, would it be fair to say that, you know, there's a number of journalists here in the courtroom today, and that if they all write a story about this and talk about your presentation and indicate that you had things in your chart that refer to Ms. Boone, and that I ask you questions about Ms. Boone, into your data set are gonna pop all of those other stories, or stories that refer to Rebecca Boone, is that right?
Can you repeat that question?
Sure, it was kind of long, it's a bad question. So, Ms. Saucier, there are a number of journalists here in the courtroom this afternoon, and if they all write stories about this hearing and mention that there were slides in your presentation that referred to Rebecca Boone, and you were asked questions about Rebecca Boone, those stories they write that refer to Rebecca Boone would then pop up in your data collection that your firm is doing for the Kootenai County Public Defender's Office, correct?
Yes.
Stories may pop up, but based on volume, they wouldn't necessarily have a very large share of voice if we were to be charting for
How can she know that?
looking at them from that path.
My question was just whether they would pop up in your data set.
They would pop up in the data set if it's about the case, yes.
And you're familiar with the Associated Press, I take it, Ms. Saucier?
Yes,
And you know how they work. A reporter for the Associated Press may write a story in Moscow, Idaho, and once they put it up on the wire, that could get picked up in all sorts of exciting places like Des Moines, Iowa, where I went to college, or let's say Crete, Nebraska, right outside of Lincoln, or any of those places, right?
that's
And they might run, because they run in a different publication, they're gonna be counted as a different story, is that right? In your data set.
correct.
Ms. Saucier, I have a question about, I think it's on 2 pages later, it's the second page of your exhibit B, is that in, all right, well then, yeah, well, it's submitted to the court, so I don't mind offering exhibit B. Do you have that with you, Ms. Saucier?
I would move to admit B.
Okay, no objection?
No objection.
Mayor, I thought I was offering it, but that's all right.
You are, well, okay,
Anybody who wants to offer it, can.
all right. It's a dual offer. I'll accept that, no objection.
We all want exhibit B. And so I apologize, Ms. Saucier, and I know it's late in the day, but your document was upside down. So is there any way you can turn that so?
Yep.
All right, so if you go down to, on the second page of the text of exhibit B, it says impressions. And do you recall discussing that term when Mr. Lawson was asking you questions?
Yes,
And so you say here that circulation impressions should be considered as opportunities to see a story, correct?
that's correct.
And not the actual.
You know what's funny? Just side note, which is probably more exciting than this entire hearing is. Media companies and advertisers sell impressions like there's something real. Billboards, when they tell you the potential impressions, just so you know, a car driving by could be 4 impressions. It's like, or they could have not seen the billboard at all. It's like if I am watching a YouTube channel and something pops up at the bottom, I may never see it, but if that video got 300,000 views, that's 300,000 impressions. So impressions are not real engagement, which is why they really don't matter, but you can use them as a data point like they are here to make it seem like 2.1 billion people are seeing these articles when that is absolutely not what's happening.
Number of individuals who read or viewed the story, correct?
Yes,
And so there's no guarantee whatsoever on any
Opportunities to see a story, not the actual number of individuals who read a story.
of the potential impressions that anybody read the story, correct?
Correct.
that's correct.
And there's nothing that any of this that tells us that what was in the story, correct? Other than maybe these terms.
The substance of the story is great questions. I mean, she's doing a great job. I don't know if it's going to prevail, but she's doing a great job in cross.
Can you repeat that question?
Sure, and there's, nothing in any of what you've provided to the court that tells you what is in a story other than the terms that you were asked to search for, is that right?
I'm sorry, I'm still a little unclear on what you're asking.
Sure. In the data set that you gathered, well, strike that. In the exhibits that you put together, exhibit A that you testified about, and then exhibit B that's on the screen now, there's nothing in that that tells us what the substance
Correct.
of the story is, other than it had certain terms in it, correct?
That's correct.
Ms. Saucier, have you ever testified in court as an expert before?
Doubt it.
I personally have not, but others in my company have.
Right. I don't doubt one bit that somebody in her company or multiple people in her company understand how this works. It does not seem like she does. And it may be unfair that they called her, and I don't want to fault her or say, she's doesn't know what she's talking about or anything like that. Her job sounds like she specializes in something other than the questions that they're asking here is all I'm saying.
In this particular exhibit and thing, what work did you do on this project?
I filtered and collected the data that we utilized in share voice chart, and I also filtered, collected, and produced the first part of the chart that was produced on the platform.
Yeah. And then what, if any, sort of quality control was there done to determine whether or not you pulled the data accurately?
Just trying to figure out how to answer that. So I'm trained on the platform. I know how to filter through the data, and I filtered through that data accurately. The data, the parameters that were in the keywords and search terms are set up accurately. So that gives us accurate results.
And have you ever used Westlaw, Ms. Saucier?
Not personally, but I'm familiar with, I know what it is.
So is the process you're describing sort of similar to running a search in Westlaw, and then you get a certain number of hits, and you know that search term actually produces those number of hits, because that's just the way the software works?
Similar. There's a little more to it than that, but
That doesn't tell us a whole lot, I feel like. Am I wrong? Am I totally off? Is it late? Am I senile? Am I losing it? Let me know in the chat if you think this is like really telling you a lot about what these stories say and how this affects the trial. The volume of interest, no doubt. I mean, he could take judicial notice of that. But anything more than that?
a decent summary of how our systems, our software may work.
I have just one moment, Your Honor.
Yes.
All right, thank you very much, Ms. Saucier. Hope all is well in Chicago.
Thank you.
Thank you, Ms. Olson. And you're not seeking any questions, Mr.
Mayor, on
Mr. Dudley is saying no. Anything to follow up? Because then we're going to take a break. You want to follow up on any questions there? We're good. Okay,
We're good.
thank you, Ms. Saucier. You can be excused. Hello?
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 Oh boy. Oof. If you stuck through to the end of this, throw a chat throw chat in the comment section if you made it through the entirety of this video to see the end. Wow. I mean, a lot of people asked me to talk about this, and I don't know. I don't know how much I really added to it. Hopefully you guys still enjoyed it. Hit the like button on the way out. More Melly talk coming, more Scott Peterson stuff coming. And hopefully we were able to get my dad on to talk about the most recent Kohberger filing prior to you watching this. But that's it. That's all I've got. Until next time, I'm going to bed. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok at Tragos Law is our handle. And don't forget to listen to the Lawyer You Know podcast featuring new episodes every week. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.